Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We had previously provided you with an update on the Indie Zone podcast entitled Idaho versus Kohberger of an April 29th, 2025 court order denying the defense's motion to strike the DP essentially as a sanction, alleging discovery violations, alleging misconduct under the U.S. Supreme Court case styled as Brady versus Maryland, and also as a violation of Mr. Kohberger's due process privileges. The state of Idaho denied any wrongdoing in this regard, and the court found that there was no basis to grant this motion, denied it. In this court order, there is reference to information the public has never been aware of before now, which was some of the contents, what was discussed during a closed and sealed hearing that was held back on October 8th, 2024, concerning defense counsel representation status. Just by way of background, this case was originally in Latah County. It was proceeding there from the date of Mr. Kohberger's arrest of December 30th, 2022, when Ms. Taylor was appointed to serve as his defense counsel, through September of 2024, when his January of 2024 motion for change of venue was granted. During the months after that motion was filed, there were a series of responses, replies, filings, hearings, because the state was opposing the moving of this pretrial and trial from Latah County. Mr. Kohberger's motion was granted in September of 2024, and venue was changed to Ada County when Judge Stephen J. Hippler became the presiding judge. One of the first things that Judge Hippler did was he scheduled a conference between the parties where the attorneys, where Mr. Kohberger, were ordered to appear in his courtroom. That status conference occurred September 26, 2024. During that hearing, which was public, Ms. Taylor stood up and advised the court that there was apparently an issue with defense counsel's contract with payment to them. After that, Judge Hippler entered an order setting a closed and sealed hearing, and that occurred on October 8th, 2024. You see the hearing, the order here, setting the hearing and requiring the defense counsel remain in place until such time as that hearing happened. It was ex parte, as you can see here. It was sealed and closed, and to be held on October 8th, 2024 at 1 p.m. There was also a motion and an order that was filed authorizing defense counsel to file certain documents under seal that were pertinent to that hearing. That hearing happened. There were apparently minutes that were taken, but they have been closed to the public. They are under seal. It is in this order of the 29th of April that the public for the first time is being provided details cited to the minutes from that closed and sealed hearing of what happened October 8th. To learn these details, go to the bottom of page 6, the last paragraph, and it says here, in addition, defendant's complaints of being unable to meaningfully review the discovery ring hollow. Defendant has been receiving discovery in the same manner for over 2 years. In that time, he has not once sought a remedy from this court to regulate discovery, such as requiring the state to provide discovery in a different format. He has not sought additional resources under ICR 12.2 to hire additional staff to review discovery or obtain litigation document control software to help organize and sort the discovery. His lead counsel, now referring to Ms. Taylor, insisted that she be allowed to take on a second high-profile capital case, despite the voluminous discovery in, and we go to page 7, this case, and the rest of the paragraph goes on to state that Ms. Taylor indicated that her practice was to personally review all the discovery herself rather than rely on associates and staff to review materials to cut through the less relevant information and point to what materials need review by lead counsel. These actions are not indicative of an overburdened defense team. Now, in between these two sentences, we see footnote 10. We go to footnote 10. It states here, a citation to State versus Schuyler Mead, Nez Perce County case number CR 35243750. C, State versus Kohberger, CR 01243165, October 8th, 2024, ex parte hearing minutes sealed. So we now are receiving some details of what had happened, of apparently of Ms. Taylor's practice to review all of the discovery herself, that she had not asked for any additional resources to assist her, such as this discovery software program that the court is addressing, and that she had also, as the court says here, he calls it insisted that she be permitted to take on another high-profile case. He is referring to the fact that defense counsel has been representing Schuyler Mead. You can look up that case anywhere on the internet, and it will provide you with some details as to what that's about. But the court here, as part of his reasoning for denying this motion on the grounds that they were overworked, overburdened, is not having it. He is finding it hollow, as he says here, because of what was disclosed and what was addressed at the aforementioned closed and sealed hearing. If you would like to review any of these documents, please plug into a search engine of your choice the term Idaho cases of interest. It will pull up a website that's maintained by the Idaho Supreme Court of high-profile cases. At one time, this Schuyler Mead case was also listed there. There is a link to Idaho versus Kohberger. You can click on the hot link. It will take you to the docket for 2024 and 2025, where you can read all of these items that are public record for yourself. If you have any comments, any feedback, any thoughts, please leave them here. Until next time, my name's Kathy. Thank you for joining us here today.